It's not to make a nonsense of the proceedings or the institution. It's to do one thing and one thing only. It is to ensure that the trial is fair. If my client, and I have to say I prosecuted from time to time as well, but if my client is acquitted at the end of the day, fair enough. If the proceedings are fair, if I've been given the opportunity to test the prosecution evidence, if I've been given the opportunity to ensure that the jury fully understand what the defendant wants to say, what his case is, then of course I accept the verdict. So that's how it should be. That's not how it always is. And in particular, in international criminal tribunals, that's the problem. So my job is to fight a case, not fight a cause. And anybody in my position who starts to blur the images between the two is making a big mistake. So I want to say this from the off. I don't come here proponing any particular cause over any other. I accept that there are very, very contentious issues in Bangladesh, and I am not going to deny that there are two sides to every story. Now, international criminal tribunals, as you're probably all aware, started at Nuremberg. They were reasonably draconian. We didn't really hear of them again until the ICTY in the mid-90s for the former Yugoslavia, followed by Rwanda, followed again by Sierra Leone. These tribunals are largely set up by the Security Council of the United Nations. And as I've said, largely they are, let's be honest, well, they can't escape some form of political motive. And they all suffered, to a degree, as I said, from dispensation of victor's justice. In response to that, the International Criminal Court, which was born by the 1998 Treaty of Rome, is designed to try to move things away into a more neutral background, but it only refers to offences and things taking place after 2002. So, as far as Bangladesh is concerned, it has no import. The Bangladesh Tribunal, I'm going to go into the background in a moment, but I regret to say, and again, reminding you that I'm fighting a case and not a cause, I regret to say that this takes the notion of justice, victor's justice, back to the Dark Ages, back to Nuremberg and before. Why is that? Well, that is what I want to explain to you over the next 40 minutes or so, with the caveat that it's not too late. If things remain as they are, then there may well be major difficulties. And Bangladesh, or the government of Bangladesh, must remember that they play a role in the legacy of international law, something which we've all fought to try and uphold and indeed improve over particularly the last 10 or 15 years. It's not too late to improve things, but if it continues unabated, we may be on the precipice of something very unpleasant indeed. Many of you know, and I don't want to patronise those of you that do, but for those of you who don't, of course, Bangladesh, or rather East and West Pakistan, was created post-war, after the breakup of the British Empire. It's probably fair enough to say that in the years that followed in East Pakistan, there was a large degree of discrimination, unfairness. Central government in West Pakistan was often criticised for failing to apply power or economic benefits, or rather bestow power and economic benefits on the eastern part of Pakistan. And this culminated with Sheikh Mujibur Rahman's 6 points in the mid to late 60s. Finally, A free and fair election in 1970 resulted in victory for the Awami League, the political party of East Pakistan. Victory over Zulfikar Ali Bhutto's Pakistan People's Party in the West was contentious. And the General Yahya Khan, the military leader of Pakistan at that time, felt forced to delay the sitting of the National Assembly until things were ironed out. That led to the mass popular movement in East Pakistan and open revolt, sparked, as many know, on the occasion of, or the tragic occasion of Operation Searchlight on the 25th of March 1971. Following that, the Pakistani army was mobilised in response to the liberation movement. There was the formation of various peace committees with their more militant branches of Razakar Bahini, with the Al-Badr and Al-Shams groups in particular, fighting or collaborating alongside Pakistani attempts to ensure that Pakistan remained united. On the other side, the freedom fighters who are celebrated to this day in Bangladesh fought hard to ensure liberation. Now, I am not here to demean or in any way to diminish the suffering caused to innocent people throughout what is now Bangladesh through the 9 or so months that followed. And nor am I here to deny the sheer numbers of those who lost their lives and were displaced. The horror is something that I know is familiar to you all. There was genocide. People were hounded out. People were displaced by virtue of their profiling as members of religious or ethnic groups. Many Hindus, as we know, bore the brunt of that. It was perhaps an episode of ethnic cleansing. But whether or not it can rightly be said that the brutality went more one way than the other, who can tell? It's often the winner who gets to write the history. I am simply here to acknowledge that there was horror in Bangladesh that year. And I can't deny the need for justice either, albeit 40 years late. I don't deny for a moment the need for a trial, in principle. And I don't deny the Bangladesh government's marvellous opportunity to create a superb example to the developing world as to how to banish impunity whilst cementing national reconciliation, pursuant to the rule of law, that is, the fair rule of law. Instead, unfortunately, as things stand, in its current guise, the tribunal arguably has all the hallmarks of a politically motivated show trial, determined to, it would appear, eradicate the Islamist opposition party, Jamaat Islami, to appease the ruling but perhaps restless nationalist party, the Awami League, who, far from seeking reconciliation through justice, seem, in part, to be bent on revenge. Now, the legal history of this is a little bit dry, but perhaps you'll give me an opportunity just to take you through this, because it is indeed instructive. The 1973 International Crimes Tribunals Act was passed in order to try those responsible for the atrocities of that war. The terms crimes against humanity, genocide, war crimes, etc., found themselves imported into this Act. The Act was based on Nuremberg. The legal framework for the trial was based on Nuremberg. And I should make this clear. There were no crimes against humanity trials. between Nuremberg in 1946 and onwards and the 1973 passing of this piece of legislation anywhere in the world, apart from Tokyo, of course, which ran in parallel with Nuremberg. Now, the purpose of the tribunal set up by that act was aimed specifically to bring to justice military personnel, notably from the Pakistani army, and the auxiliary forces who collaborated with them, the Razakar Bahini, Al-Badr, Al-Shams, etc. But in an admirable gesture, and the admirable spirit of peace and reconciliation, Sheikh Mujibur Rahman ensured, pursuant to a pact with Pakistan, that several hundred Pakistan soldiers were freed shortly after the war, and following that, Presidential Order Number 16 in 1973 offered what appeared to be a blanket amnesty to all participants who acted, and I quote, in connection with the conflict. Thereby, the International Crimes Tribunals Act of the same year apparently was laid to rest. Both sides appearing, it would seem, to want to reconcile, to put the past behind them and to move on. Until, that is, the year of 2008, almost 40 years later, 37 years later, the Awami League swept to power with a landslide majority, one of the most compelling aspects of their, or points of their manifesto, being their determination to resuscitate the International Crimes Tribunal Act and bring to justice those responsible for the war. Now, whether the trial is in fact a tool of political expediency, designed to mask socio-economic difficulties at home, or a genuine desire to heal the wounds of the past, the promise of the trial has triggered a widespread populist fervour for vengeance amongst many in this, the war's 40th anniversary year. If it was a popular, or rather, I'll put it this way, as an electoral pledge, it proved tremendously popular. Now, the difficulty, of course, is that 40 years later, the military are all gone. Most of the auxiliary leaders either left the country and fled, or they've died. The remaining suspects, those who have been placed under arrest, apart from being very young at the time, and very old now, the oldest suspect yet to be arrested, but likely to be soon, Ghulam Azam, the leader of Jamaat-e-Islami at the time, is now 85. All of these people, current suspects, were civilians. And so in 2009, the Act was amended to add the category of individuals to those military and auxiliary members of the anti-liberation forces originally targeted by the Act. In contrast, and this is a very salient point you might think, the immunity for those who fought with the liberation forces, irrespective of their conduct, remains intact. This trial, or this Act, is targeted, it would appear, to just one side of the conflict. And that is where I bring back this term victor's justice, this thing that really tribunals need so desperately to try and move away from in order to encourage its sense of integrity and propriety, legitimacy. It has to have the appearance of being fair, of addressing all sides of the conflict. By 2009, all the tribunal needed then was some suitable targets and some fancy legal footwork. What do I mean by that? Well, the Bangladeshi constitution, by now well established, has an article, Article 31, which states this: citizens are to enjoy the protection of the law and to be treated in accordance with the law, and only in accordance with the law. and is the inalienable right of every citizen. Freedom or equality before the law, you might think, is one of the cornerstones of any, if you are charged to appear before the International Crimes Tribunal. Because in 2009 the Constitution was amended. Article 47.3 effectively removes the protection allowed by Article 31. It also removes the constitutional right not to be tried on retroactive law. I'll speak more about that later, but that essentially is law imposed today on acts in the past. It also removes the right to interlocutory appeal to High Court and Supreme Court. In other words, decisions taken by the judges during the proceedings cannot be appealed to a higher judicial body pending a trial. It's an inalienable right in any modern legal system. In addition, the Act's removal of the 1898 Criminal Evidence Act, which was passed in the same year of the English Act of the same name, which formed the basis of English rules of admissibility for over a century, has served to deny the accused the most fundamental safeguards, especially concerning rules over the admissibility of evidence. And I'll come on to the significance of that later as well. In essence, what we have is this, that the addition of Article 47.3 into the Constitution and the subtraction of the 1898 Criminal Evidence Act is a deadly combination, which if misused, and I use those words with emphasis because the trial hasn't started yet, but if those things are, or if that scenario is misused, I'm afraid this creates the perfect habitat for a political show trial. Worryingly, a judge currently sitting in the Supreme Court noted just recently in proceedings brought against the constitutional amendment that a reasonable distinction can indeed be drawn between the rights afforded to what he said were ordinary citizens and other citizens accused of war crimes. Well, they are only accused, they are not convicted, and there should be no distinction until they are, if they are. Examination of further provisions of the International Crimes Tribunal Act, in my submission, if you like, served to further illustrate this. There are a series of pre-trial provisions within the Act that can only be said to be draconian, which cut against, once again, any of the minimum standards that one would expect within a modern democracy. First of all, investigators appointed by the government, as they all are by law, have the right to question or detain anyone without notice. Secondly, those being questioned have no right to silence in interview. Thirdly, the questioning of detainees takes place without a lawyer being present. Some of the suspects who we represent were allowed a lawyer present, except he was allowed only to sit in an adjacent room. There is, fourthly, no right to prior disclosure before interview, so you can be called in without any idea what you're going to be asked about. And unfortunately, fifthly, experience has shown, because we monitor the media every day, that investigators, having been grilling the suspect all morning, are in the habit of coming out at lunchtime and giving impromptu press conferences informing the waiting media that the suspect had in fact confessed. It's happened on more than 3 occasions. That's just pre-trial. What about the rules of procedure during the trial? Well, it just gets worse, really. As I've said, first of all, the traditional rules enshrined within the 1898 Act have been ruled out in relation to suspects before this tribunal. They're still extant for domestic criminal matters. Hearsay, secondly. Well, hearsay, the admissibility of hearsay is allowed in modern tribunals these days, to a degree, within reason. But the International Crimes Tribunals Act goes out of its way to provide that in this trial, notwithstanding the 40 years time lag, evidence can be, or admissible evidence can be drawn from newspaper articles, magazines, news reports, radio reports, etc., etc. I have seen myself, in respect to the first defendant to be tried, a man called Delwar Saidi, who is perhaps Jamaat Islami's leading religious individual. I have seen some of these documents. I'll put it politely and say that if that is the sort of thing the court are going to rely on, then this amounts to nothing more than prosecution by rumour. The third draconian rule that applies to the conduct of trials is that judges have unusual powers, shall we say. In other words, they have unfettered rights to question witnesses, whereby the defence have no right to re-examine the witness after the judges have finished. If the defence are to call any witnesses, the prosecution are entitled to address the court last when it comes to final submissions, which is contrary to one's experience anywhere in the world. When the defendant or the suspect is arraigned, that is to say the charges are read out and he's asked to enter his plea, he is forced to enter his plea immediately without recourse to legal advice, notwithstanding the fact that he's heard the charges for the very first time. This itself happened in Saidi's case on October the 3rd. If you just think about that for a moment, somebody's being asked to plead, guilty or not guilty, to an indictment, in his case 20 charges long. Charges which he is hearing for the first time, the product of a prosecution inquiry or investigation that has taken 12 months. Saidi was not allowed even 5 minutes to consult with a lawyer. It's worse than that, though, because 3 weeks having entered one's plea, the trial starts. I just said the prosecution have a whole year to prepare their case. The defence, knowing the final, or for the first time seeing what the charges are, have 3 weeks, with nothing like, of course, the resources that the prosecution had. I had similar problems in Sierra Leone, but where we're dealing with cases which are supposedly to end with capital punishment, it's perhaps a little bit more worrying here. And then there's this. It's a little bit more complicated, but I want to take a bit of time over it because this really cuts right to the core of how ill thought out this act is. And it's this. You've heard me talk about crimes against humanity, genocide and what have you. Not many people actually know what crimes against humanity mean. It's quite a complicated subject. Unfortunately, given the state of this act, nobody in the Bangladesh War Crimes Tribunal appears to know what they mean either. Why? Because the act doesn't define crimes. Now, I want to just concentrate on this for a moment because this is absolutely fundamental, and it's fundamental when one remembers, of course, that one of the most fundamental rights of the accused is that he has to know the nature of the case against him. Article 14 of the International Covenant for Civil and Political Rights is repeated in the international or the ICC statute. It's even repeated at Section 16 of the International Crimes Tribunal Act. I wonder if I can ask the gentleman just to sit down.
I wonder if you could actually turn off your camera.
Oh, sorry.
The crimes. Let's go back to crimes against humanity. Crimes against humanity was first invoked at the Nuremberg War Crimes Tribunal. Article 6C of Nuremberg defined crimes against humanity thus, and remember this is 1946. Remember, crimes against humanity wasn't tried again until the 90s. So my point is this is the law on crimes against humanity as it was in 1971. So defined crimes against humanity is this, namely murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war, or persecutions on political or racial grounds in execution of or in connection with any crime within the jurisdiction of the tribunal. And it stated that leaders, organisers, instigators and accomplices participating in the formulation or execution of a common plan or conspiracy to commit any of the foregoing crimes are responsible for all acts performed by any person in execution of such plan. A bit of a mouthful, but in actual fact, when you break it down, it's quite straightforward. Implicit in that definition was the requirement of the nexus of the nexus between the crimes and the international armed conflict. That nexus with an international arms conflict was crucial, or a crucial ingredient for the definition of crimes against humanity in 1971. International conflict, not a domestic one. Now, the current definition of crimes against humanity was really defined in the Cambodian tribunal more recently. And it stated that as of 1975, 4 years after simply some form of training to bring them up to speed on how to grapple with what, after all, are very complicated concepts of international law. International law is complicated. It's a very recent commodity. It's changing all the time. I was criticised in the tribunal for saying these things. None of my business. Well, it's up to them to say that, but really, isn't it only fair and proper that if a tribunal is going to take something like this on, it takes every opportunity it can to ensure that the legacy it leaves behind is a worthy and admirable one. I've already said that there's no right of interlocutory appeal during the trials. That is to say, decisions taken by the tribunal's judges can't be referred to higher courts. The tribunal's decisions during the trial process can only be reviewed, it seems, by themselves. There is no right to challenge the appointment of any judge for perceived bias, should that ever arise. On that issue, here's another worrying little anecdote. Back in 1993 and then again in 1994, a commission of inquiry decided to adjudicate the conduct of various individuals during the War of Liberation. It just so happens that the majority of those placed under the spotlight are those in detention today. Most of them luminary leading members of the Jamaat-e-Islami party. They were all roundly condemned. There was no trial or anything like that. It was just a document prepared by a commission, presumably appointed by the government at the time, that drew certain conclusions. At the self-styled People's Court in 1992, the same individuals were ceremonially, well, not for real, it was simulated, but there was a ceremonial hanging. There was a ceremonial hanging, in fact, last weekend. It was published in the newspapers, garish photographs of the Jamaat-e-Islami and one BNP detainee. There are 6 detained at the moment. A garish photograph of people in an Awami League meeting pretending to be hanging from nooses with their tongues hanging out. very unpleasant. There is an atmosphere being fomented which seems to suggest that we are heading for a confrontation. The only right to appeal in this tribunal, in fact, is that of conviction and sentence. And as I've already said, the Act empowers the tribunal to impose the death penalty. Well, I've gone over what the tribunal, I suggest, is wrong with the tribunal. Can I just sort of move on to the situation today, and I'll try and sort of move a bit more quickly over this. As I said, on the 3rd of October, Delwar Saidi, after a year-long investigation, was finally formally charged with 20 counts of crimes against humanity and genocide, being in custody for 14 months. The first 4 months, it would appear, unlawfully, because it wasn't until an amendment to the Act late last year that we were told that somebody could be held without charge in detention. No habeas corpus there. The other 5 detainees that we represent are still awaiting charge. They too have been in custody now for more than a year. Advising these individuals is very difficult. The Act did originally, or still does, provide for the instruction of foreign counsel. I was instructed pursuant to that. Unfortunately, the Bar Association, or the Bar Council in Bangladesh, has elected not to admit foreign counsel to the bar for the purposes of this trial. That is up to them. But when one colleague of mine flew to Dhaka about 2 months ago, he was summarily turned back. It seems at the moment we are persona non grata. It's difficult to advise because the indictment is vague, as I've said. The indictment contains, amongst those 20 charges, duplicitous charges, that is, charges that appear to allege more than one offence, sometimes up to 3 or 4. There's a lack of identifiable victims, a lack of specific dates on the indictment. Some say the event took place, and I quote, towards the end of the Liberation War. How are you supposed to defend that? There is no provision for trial monitoring. There's no provision for the recording or translating of proceedings. Laptops have been banned from the courtroom. The only reporting, it would seem, would be that from largely government-backed newspapers. There is an atmosphere of hostility. Violence has accompanied several of the court appearances. Notably, on the 19th of September of this year, there were hundreds of arrests in Dhaka following a Jamaat-e-Islami rally. Our Bangladeshi lead counsel, or certainly who's running the show as far as Dhaka is concerned, has been threatened with arrest. I think he's actually currently on bail for his part in that trouble, despite the fact that he was in Europe at the time. I saw him myself. A key defence witness, ironically a former freedom fighter, on the side of the pro-liberation forces, was recently arrested, as well as 5 further defence witnesses who my team in Dhaka have been speaking to and taking proofs of evidence from. A British journalist, David Bergman, working for the New Age, a Bangladeshi daily opposed to the government, has been called before the court on the 27th of this month to answer a contempt charge. What did the government say in response? Because it's only fair that I give you both sides. The State Minister for Law, Kamrul Islam, said this last week: the International Crimes Tribunal trial process will be more neutral and transparent than that of other war crimes trials so far held elsewhere in the world. It'll be exemplary for the world community. Lofty words. He added, the ICT was working with full independence and complete neutrality. The Prime Minister, Sheikh Hasina herself, addressing the United Nations General Assembly in New York in September, said, and we can all back her with this, we can all agree with this. I believe peace prevails when justice prevails. Well, how right she is. But did she give herself away a little bit when she was quoted as saying this moments later in relation to the tribunal, the suspects of the tribunal? I quote, "Their eventual punishment will strengthen our democracy, demonstrating that the state is capable of just retribution." Could it be that the results are already in? Today in Dhaka, I was there myself in March, the atmosphere is a little sinister. You see huge Orwellian murals, something out of Soviet Russia almost, celebrating and commemorating the struggle of the freedom fighters. But the sense is more of vengeance than reconciliation, and of the political culture that at the moment appears to brook no dissent. Having been followed around Dhaka and later again in Kuala Lumpur by what I can only describe as rather amateurish secret service agents, I can testify that to myself. This weekend at an Awami League symposium in Dhaka, entitled "Brutality at Jamaat-e-Islami and a Delayed Trial of War Criminals," there were calls for the banning of Jamaat as a political party altogether. Elsewhere, contrary to Kamarul Islam's lofty promises, the ICT has received nothing but criticism from diplomatic and humanitarian sources from all over the world, including my old adversary at the Special Court of Sierra Leone, the US Ambassador for War Crimes, Stephen J. Rapp. Civil rights activists, particularly Lord Avebury here in the UK, the International Bar Association, Human Rights Watch, the International Centre for Transitional Justice, ICTJ, Amnesty International, have all called for the ICT to amend itself to adhere to current international standards. They don't, so far, appear to be listening, and only time will tell if they do. Where better to look than the statutory framework of the ICC, of which Bangladesh is a signatory, for an improvement to that framework? One would have hoped that that is exactly what the government would have done, because the ICC statutory framework, rules of procedure, etc., are the benchmark set up in order to avoid those old hybrid and ad hoc tribunals which fell victim to the notion of victor's justice. In her address to the General Assembly, Sheikh Hasina said, as a state party to the Rome Statute of the International Court, her government believes in the statute's provision of bringing perpetrators to justice. And I quote, "It is the only way to heal the wrongs of the past and bring national reconciliation." If that was an acknowledgement that the ICC standards should be imported, then of course we applaud her. Again, I repeat, I in principle have no objection, and nor should anybody in principle, to this tribunal taking place, no matter how long ago these crimes took place. But if she's not willing to adopt the principles of the ICC statute, having said that to the UN General Assembly, then it might appear a little hypocritical, mightn't it? Now, there is that old saying that many of you have heard, "Let justice prevail though the heavens may fall." One hopes that justice will prevail, because trials of this magnitude and geopolitical significance, and let's not forget that, need not just to be fair, they must appear to be fair. At the American Society of International Lawyers Conference, I suggested that the trials had the appearance of being, however, politically motivated. The Bangladeshi ambassador sneaked in. He'd been invited but didn't respond. Instead, he crept in unannounced, and he reacted in hostile fashion How dare I suggest it was politically motivated? I simply replied that it was a bit of a coincidence that 5 of the 6 detainees just happened to be leading members of the main Islamic opposition party. Tension is mounting. There have been mass demonstrations in Dhaka. They've already turned violent. They've had to be forcibly put down. One's fear is this, that as of now, the trial looks set to be a rallying point for both secular Awami League nationalists and anti-government, largely Islamic opposition. One can only hope that the trials do not signal a call to arms for extremists on either side, and that the government revisit their approach to the tribunal with a new sense of balance and restraint. For what a tragedy it would be, 40 years after the event, if these trials were to result in the same hatred, chaos and violence that we were told they were supposed to put to rest. Thank you very much.
Thank you very much, John, for that.
Sorry I overran a bit.
Sobering account. We proceed to Sharmila Bose. I neglected to mention her recent book, Dead Reckoning, which is receiving a great deal of attention and is on the events of 1971.
And thank you, Mr. Khaled, for your very detailed and substantive talk. And I'm sure the audience would mostly like to ask you questions and have a discussion with you. So I limit myself to just a few remarks. As Faisal has just reminded you, as if you needed reminding, I have recently written a book about the 71 war. And for the most part, that book contains details about incidents. The point was to find out what happened in a large number of violent incidents during that conflict. And on the basis of my experience doing that work, I certainly agree with John Kamei that trials should be held. And it's entirely appropriate in my view, from my experience when I searched for that book, that it's appropriate to hold war crimes, trials for crimes against humanity with regard to what happened in 1971. Because what I found was in practically every incident that I looked at, absolutely ghastly crimes were committed by very many people. And so the question of whether after so many years trials are the right thing to do, I would say yes. I think there's a place for trials because there are so many victims, and on all sides of the political conflict there, who feel very acutely, and I feel with them, that they have been denied justice, and people should not be allowed to get away with very serious crimes, no matter how much time has passed. So I think it's proper to have trials. Now, then the question is whether one could also have a truth and reconciliation type process if you have trials. Or if you have truth and reconciliation, whether that excludes the possibility of trials, which are, of course, adversarial in nature. I would submit to you that you could probably do both in the case of 1971. And one of the reasons why I'm still in favor of having some truth and reconciliation procedures in the case of 71 is that there are some cases where, such as the many disappeared people, There are many disappeared people, again from both sides. I mean, there are people, for example, from West Pakistan or the non-Bengali population, generally termed Biharis, who were killed during that conflict. There are many Bangladeshi nationalists who disappeared because they were liberation fighters and so on, presumably executed. And their families and loved ones have no closure. That in many cases, on both sides of the conflict, people don't know what happened to their loved ones. They assume they're dead in many cases, but bodies haven't been found. They don't know, what their last moments were like. Nobody has had a funeral, like that sort of thing. It's very disturbing for the families and loved ones. And so, in many of these cases, I felt while hearing about and reading about many of these incidents, that in many cases you will never know what happened. You will never know where the body of your loved one may be, or how he or she met his or her end, unless somebody who was involved in committing that crime tells you. And unfortunately, unless you have a truth and reconciliation type procedure, nobody is going to come forward with this information. And the price you pay for that is, of course, that you have to give some form of immunity to some people. So at some point, if both sorts of procedures are going to take place, then someone in authority would need to take a decision about which acts would be tried and which other people might be given some immunity from prosecution if they came forward and divulged important information which would give some closure to the families and loved ones or victims on all sides. So there's a balance to be struck using judgment. I think there's room for both, but it's a very difficult judgment to make. The question, of course, with regard to trials is who should be tried and where and how. And here I think it's very important in the quest for justice that anyone who is accused of serious crimes should be the target of an indictment. And during 1971, all the warring parties committed acts which has led to people from all sides being accused of very serious crimes. So there are many people, as Mr. Kame indicated, there are many people who are in the Pakistani armed forces. And they are, of course, not in Bangladesh. They're either in Pakistan or somewhere else. There are also many people who may be from what is today Bangladesh, but not necessarily there anymore. So there are a number of people on both sides of the political conflict who are accused of very serious crimes who are not in Bangladesh. This naturally poses a practical problem for the Bangladeshi government, but I think it's very important that all the people who are accused of serious crimes should be indicted in some manner, even if you cannot actually proceed with a prosecution. Because otherwise it's not fair. You can't, I think, if you speak in the name of justice, you can't just pick and choose a few people from a few groups. You need to treat all the people who are accused of serious crimes equally. And so, whether people belong to those who belong to the Pakistani armed forces, and there are a few Bengalis in that as well, mostly from West Pakistan, a few Bengalis. And then people who are in East Pakistan, who are resident there, whether Bengalis or non-Bengalis, whether those in favor of the liberation of Bangladesh and those in favor of retaining a united Pakistan. There are all these different groups of people of different political views, different ethnicities, different religions, etc. And I think that all the people from all of those groups who are accused by the victims' families and so on should in some form be indicted, and I don't mean in a legal sense necessarily, but they should all be there for all of us to see as the accused people. Then you can make practical decisions about whether or not to proceed with a prosecution in some of these cases. And such decisions are made all the time, and I'm sure Mr. Kame is much more of an expert in this than me. In any kind of prosecution case, you make a decision whether or not you are going to proceed. For example, based on whether you have adequate evidence to proceed. So when, say, the Crown Prosecution Service here doesn't proceed with a case, it doesn't mean that people there think that the person who was accused is not guilty. That decision might be taken because there isn't enough evidence to move forward. So you can make people make practical decisions all the time. So you could take practical decisions, the Bangladeshi government could take practical decisions that we don't have certain people in our jurisdiction. We think they are accused people, but we can't do anything about them now. And therefore we will proceed against those who are in our jurisdiction. I mean, ideally those who are not in Bangladesh should also be brought to trial if they face serious enough crimes. But as far as I know, Bangladesh is not in a position to go around kidnapping people and bringing them to justice, unlike some other more powerful countries of the world. So Bangladesh has to be content with a more limited procedure. But even there, it's important that anybody who is in the jurisdiction of Bangladesh, who is accused of serious crimes, should be proceeded against. And that includes people of all political views. And here I am very much at one with Mr. Cameron's views that if you just pick one political party in the main, and they happen to be the opposition in the present time, this doesn't look fair, and justice must be equally applied to everyone regardless of politics. This is very important if the quest is for justice. Where to hold such trials? Bangladesh could have asked it to be held internationally. In fact, the International Committee of Jurists in 1972 had recommended that trials be held internationally and with a majority of judges from neutral countries. And that sounds an eminently sensible proposition. Now, for many reasons, the International Court may not wish to proceed with the 71 trials. Again, there are many practicalities involved. There's so many crimes committed around the world. If we say we cannot proceed with cases against all the crimes that are committed internationally and so on. But if that's the case, there was nothing to prevent Bangladesh from adopting the international norms, as has just been stated. Because it's already there, it's ready-made. You don't have to invent them all over again. It's there, there's an international consensus about them. You just apply them in your own jurisdiction. Though I must say the recommendation in 1972 that judges should be from neutral countries is a very good one, because that just takes the politics out of the procedure. And it's disappointing that none of these possibilities have been followed by the present Bangladeshi government so far. I am quite confident that if the Bangladeshi government does take the opportunity that Mr. Kame says is still present to make the necessary changes so that the procedure is seen as a fair one, a just one, then I'm quite confident that anybody who did commit serious crimes in 1971, against whom there's reasonable evidence, would be convicted by a fair court. There's no reason to think that if there are members of Jamaat who committed serious crimes, against whom there's reasonable evidence, there's no reason to think that a fair and just international and neutral court wouldn't convict them. They would. And that would have far more weight than a conviction that might come out of the procedure that has been so far described by Mr. Kamel, which is extremely worrying. I hope very much that the Bangladeshi authorities take whatever opportunity still remains to correct this process, so that in the interest of justice there is a process that's truly fair and is seen internationally as fair. It seems to me so far from what I've read in the media and from what Mr. Kamel has just described, that unfortunately so far what we have is what I would say is a desperately sad missed opportunity.
Thank you, Ms. Kamel and Sharmila, for your comments. My interest in this is from a very comparative rule of law society perspective, and I'm going to try and give a balanced view on why Bangladesh as a rule of law society still holds out some hope, and I'm going to just do a political-legal analysis of the tribunal and certain other aspects of Bangladesh's engagement with international law. And in terms of the Act, I think there are two frameworks of analysis you need to look at when the Act was first made in 1973 and now it's used in 2009. In 1973, in many ways, the Act is much ahead of its time. And I say the Act was much ahead of its time in 1973. If you look at the definition of genocide in the Act, it includes political groups, which is specifically excluded in the Genocide Convention of the late 1948, I think. And that's a dubious history of the Genocide Convention, that political groups are expressly left out because of hectic negotiations during the drafting of the convention. But you see here, you have the Act including political groups as one of the target groups in its definition. And another important aspect in which it was the positive aspect of this Act is that in 1973, if you look at the fair trial provisions, and I agree with Mr. Kamel that there are very grave concerns as far as fair trial protections go, but in 1973 you have to still remember that the ICCPR is not in force. The ICCPR has not come into force. Bangladesh itself does not accede to the ICCPR until the year 2000. But despite that, some of the protections, fair trial protections in the 1973 Act match that of the ICCPR, or if not better than it. In terms of my concerns with the Act, as far as retrospective application of the law is concerned, I think I'm going to differ with you slightly on that. In terms of as far as applying crimes against humanity to non-international armed conflict is concerned, yes, you don't. And as far as international law is concerned, it does not have to be out there in a treaty or in a convention or in an act that's promoted. There's very much the existence of customary law at that point. And from 1946, And from the Nuremberg and the Tokyo tribunals to 1973, when this act is, or 1971, when the acts are perpetrated, customary law has developed sufficiently to cover the acts, crimes against humanity, certain aspects of crimes against humanity. But there is a problem with the act, even in terms of its definition of crimes against humanity. And it leaves out a very important aspect of what is internationally now recognized as what constitutes a crime against humanity, and that is that it has to be a part of a larger plan. That whatever you, murder, extermination, enslavement, all these other acts has to be part of a larger plan. This element of that it needs to be a part of a larger plan is left out of this act, and that is a problem. And also in terms of retrospective application of the laws, another drawback is that its definition of war crimes, its inclusion of war crimes for non-international armed conflict. And yes, I mean I don't disagree that it is a non-international armed conflict, and the distinction is important between international armed conflict and non-international armed conflict because the provisions of the Geneva Conventions apply differently. And in terms of war crimes, this act is an exercise in retrospective application because war crimes in 1971 for non-international armed conflict is not in place. As a matter of customary law, war crimes for non-international armed conflict is not in place when these acts are committed. And in terms of other provisions of the Bangladesh Constitution and provisions 47.3 and 47A introduced by the First Amendment are extremely problematic provisions. They say that the provisions of this act, the International Crimes Tribunal Act, cannot be challenged before any court in Bangladesh. Any provision of the Constitution cannot be invoked to challenge this act. And the First Amendment also provides that anyone accused of any of these crimes in these acts cannot get the benefit of any remedy that the Constitution has provided. So there's no habeas corpus. The Bangladeshi Constitution has, in Article 102, certain protections, that certain remedies that you can seek from the High Courts and the Supreme Court, which are explicitly excluded by the First Amendment. And you can't invoke it if you're accused under this act. However, there's still hope. And I say there is hope because Bangladesh is one of the very few countries in the world, and as far as I know, one of 3 countries in the world, whose Supreme Court has the power to strike down constitutional amendments. Of course, the doctrine is borrowed from its neighbor, of saying that certain constitutional amendments cannot, even if it's a constitutional amendment, it cannot violate the basic structure of the Constitution. So in 1989, in a case, the Bangladesh Supreme Court struck down the 8th Amendment as being unconstitutional. And it is a big deal. This power of a court to strike down a constitutional amendment is a big deal. I mean, if you just have to look to the US debates or look to the UK Supreme Court and now the UK Supreme Court and the House of Lords decisions, and this counter-majoritarian effect of the judiciary and that its willingness to check the legislature in such a drastic manner is important. And that has to be kept in mind. And as far as the Rome Statute is concerned, and signing up to the ICC, Bangladesh is the only South Asian country to have done so. No other South Asian country has signed or is in the process of even accepting the Rome Statute of the ICC. India is a very strong opponent of the International Criminal Court, along with its dubious partnership with the United States, which is another strong opponent of the International Criminal Court for very different reasons. And I want to take this point this opportunity to go into South Asia's engagement in with international law per se. India's opposition to the International Criminal Court is with the powers of the Security Council. That the Security Council can refer any case to the International Criminal Court, or it can stop any case that is before the International Criminal Court. And of course, the link becomes obvious because it is very much tied to India's demand for reforming the Security Council and India wanting to be part of the Security Council. And India is nowhere close. There is a strong civil society movement in India to get India to sign the Rome Treaty, but I don't think it's going to happen. In terms of engagement on this very issue of the 1971 war, India has a rather dubious history in this. Pakistan took India to the ICJ, filed a case in the ICJ against India because India held on to about over 90,000 prisoners of war after hostilities had ended. And after it filed the case in the ICJ, the two countries negotiated, and India decided to hold on to only 195 prisoners of war, whom they wanted very explicitly to prosecute for war crimes or crimes against humanity or genocide. And that was very clear that these 195 people, India thought, should be prosecuted either in Bangladesh or in India for Commission of Crimes, for Commission of International Crimes. But when it comes to the Shimla Treaty, the Shimla Agreement, the 195 individuals are handed over to Pakistan in the spirit of, and the treaty says that, in the spirit of moving on and forgetting the past. And so you have these 195 individuals being handed over and no efforts towards justice at that point. India's own role as far as international law is concerned, its involvement in Sri Lanka through the IPKF, and particularly the massacre at the Jaffna Teaching Hospital, where Indian forces killed about 70 people, including nurses, doctors, patients, has largely gone unaccounted for. The Sri Lankan government in 2008 finally called it as a crime against humanity. Nothing has happened on that front. And in terms of India, of course, has its infamous reservation to the ICCPR, to the Covenant on Civil and Political Rights on Self-Determination. It has signed up to the ICCPR on one condition, and I mean, there are four, but one of those conditions is this: it does not agree, or rather it clarifies on its behalf what it means by the right to self-determination as a clear attempt to exclude Kashmir's claim to self-determination. So that provision has been made. Sri Lanka, of course, and it's an interesting comparison with Bangladesh. What Sri Lanka has done, despite a clear indictment from the UN Secretary General's Expert Committee's report on the nature of international crimes in Sri Lanka, which was constituted after the war ended, Sri Lanka's approach has been to form what is known as the Lessons Learned and Reconciliation Commission. Okay? Lessons Learned and Reconciliation Commission, which everybody agrees is a sham, is a government body which has lots of problems with its procedure, the way it takes testimony, the way it accepts expert witness, its hostility towards experts that are not pro-government. So clearly there's Sri Lanka has set up this commission so that it can show the international world that it is doing something about it, and that there is no need to internationalize this whole procedure. In Sri Lanka, a lot of the debate has been framed in the context of, if we push too hard on this on this need to achieve justice, what we're going to sacrifice is peace. And that is very often the framework of the debate in most transitional societies. And I think it's a false distinction. And just one final point on India, what sticks out in terms of a case that closely resembles is the Gujarat riots, and it shows you the attitude of the Indian Supreme Court. One of the activists referred the case to the United Nations Human Rights Committee, and the Supreme Court was quick to express its extreme displeasure by saying that it is competent enough to handle its own matters and it does not need any international advice on it.
Thank you very much. I think that gives us a broad legal perspective of the region. Since we only have half an hour, I will sacrifice my remarks, which are of no consequence in any case. Since I'm no legal expert, so I can't speak to any of these issues directly. And we can open up to questions. Yes.
I'm not a student of law, I don't understand much of it, unless it does impact me, my life, directly. But I was listening to Mr. Kame and all the other panelists here. The first question comes to mind is kind of a sociological nature, because I'm myself a student of sociology. So I was thinking first let me thank you for bringing up all these issues that is being going on in Bangladesh. And when I was looking at the things, and I also saw your presentation in Washington, so which was you were a panelist with Stephen Rapp.
Yeah.
So I was listening to it, and it seemed really interesting what he had to say and what you had to say. So what my understanding of the whole situation is, I have been brought up in that country, and we have seen, and that's part of our life. And now the country, whether or not to reconcile or to go for trial and everything else. So very, very well taken. I think there is still hope if Bangladesh government takes your points into account. But the two questions that I have, one is...
They're not going to.
Okay, so yeah, that's probably what you are thinking. I don't know what's happening. Okay, all right.
The trial starts on the 30th of October.
Okay, but maybe there are two things that I was really wondering. Number one, is it a really international court or is it a domestic thing? As far as I sort of read through newspapers, I thought it was a domestic court which is dealing with something which is have international importance. That is one of my questions. And the second thing goes to the retroactive effect. As a sociologist, it seems quite... I know I'm not a lawyer, so as a sociologist, it seems quite natural to kind of look for this trial that, okay, there were crimes done, even if it's 40 years afterwards, it's a good start that the country is trying to get back to what happened in the past. But in terms of retroactive uses of the international laws, I think I saw somewhere that Australia actually did use that at some point. And ICA, which is, I think, the Australian International Court. I think you might look it up. I don't know whether or not it was the case, but I think I read somewhere that was the case. And the second thing is, when you talk about the politicization of the whole thing, and it's bringing the international standard in, if that is a domestic court, whether or not international standard, trying to bring international standard in it, you are kind of diminishing the domestic political, or you're not taking into account domestic political situation, which came up quite often when you were talking in terms of different changes that have been done in the constitution. And those were done in specific domestic political situations. And those had the reasons. And if you don't take those account, but you take account of the fact that hundreds of protesters were detained in 2011, just the day before the Hartal, where the 100 protesters were detained, there was another Hartal, or strike in Bangladesh, which was in order to protect the resources of Bangladesh. That was completely a different topic, different issue, different fight. And in that Hartal as well, there were 142 people detained. So it doesn't really say that whether or not this case against Jamaat-e-Islami is specifically targeted, or it is more about the government itself and how the South Asian governments deal with these kind of protests. So the Hartal the day before also had 100.
Can I stop you? Can I ask what your question is? Because,
I'm coming. Yeah. So one question was, I told you about whether it's a domestic.
Yeah. Can I answer that first of all?
I didn't finish my question. If I could, then I could sort of.
Well, it's taking a long time. So I don't want to be discourteous, but can I just answer the first part first? It was a very good question concerning the international domestic nature. It's called the International Crimes Tribunal Act. It was originally set up as an international tribunal to try international defendants. But as I explained, in 1973, after the Act was commissioned, there was a general amnesty, Presidential Order 16, basically amnestied anybody in connection with the trial. Now, you're absolutely right, it has really become quite domestic, but it's quite perverse because it's a domestic trial which is attempting to try international crimes, crimes against humanity, genocide, war crimes, etc. Now, that is unique. Let's just say that was the norm. The thing is, the difficulty is that if it is a domestic trial, why is it doing away with domestic law? Why has it banished the 1898 Criminal Evidence Act and essentially brought in a constitutional amendment which denies the accused any of the legal safeguards, and then of course Article 47 denies Article 41, which is the right of freedom before the law, equality before the law, etc. So, yeah, it essentially is a domestic trial. It's become that because it's deliberately metamorphosized itself into that. In 2009, when the Act was resuscitated, their aims changed. They brought in the individuals, the civilians, they've maintained the amnesty in relation to foreign individuals, they've maintained the amnesty in relation to the freedom fighters. Now, I'll just very quickly come on to the next part of what you were saying, which is the politicisation. You were saying, if it's an internal trial, shouldn't it be run on the politics of the day, if you like? Well, yeah, why not? If that's what the people want. But it's a very medieval approach, if I might say so. Because I don't want to reiterate the list all over again. But if you're happy with a criminal justice system that deliberately isolates these accused from anybody else charged within the domestic criminal system, where the Supreme Court, rather than intervening and quashing this amendment, has actually gone on record saying that there should be a distinction between the rights afforded to ordinary citizens on the one hand and other citizens accused of war crimes on the other. So if your whole judicial system seems to be moving in one direction, that direction being to discriminate against the alleged war criminals by denying the traditional rights that accused would have, no right of silence, they can be picked up at will at any time by government-appointed investigators and prosecutors. All that I told you about the defence having only 3 weeks to get their act together, and they've got to actually put all their witnesses before the court, before the prosecution have even started their case. There's no right of interlocutory appeal. I could go on and on and on. If you, I'm not saying you personally, but if one was happy with that type of curtailment to freedom before the law, something more akin with something we used to see in Soviet Russia than something in the modern day, then fine. But I say that just as an ordinary lawyer with an ordinary sense of justice and equality amongst men, women all over the world, there are basic norms and basic freedoms that have to be abided by, because if you don't, you're falling into the trap of running some sort of Orwellian despotic state where freedom is reserved for the privileged few who are in power, and the rest of the country are really under a very frightening type of coercion. And that really isn't any type of law that I can stand for.
Can I finish the question? The last one.
Very briefly, yes.
Okay. So I didn't say that in fact, in the beginning I said thank you for bringing up those loopholes in the whole system. That's really good. But for us, as a sociological understanding of it, it's more important to see that the process started. And the last question that I had for you is, people wanted that, and that was very popular in the last election. And it was kind of coming from the 40-year-old aspiration from the people itself. So,
but they're banishing the rule of law to do it.
No, I completely agree with the facts that you say about the loopholes. But the fact that when you are saying these things and that international standards have to be applied to it, it's fine. But they're trying, and that's the thing is, they actually went out.
Why be a member of the ICC if you're going to drive a coach and horses through the minimum standards that the ICC demands? So I'm not going to get into an argument with you.
Can we take 2 more questions or 3 more questions together, and then you can address this one as well. Gentlemen from Jersey, yes.
As per the Nixon administration document, this is one of the unprecedented genocides since the Nazis in Poland. Now, you mentioned that international law cannot be imposed because Bangladesh was not technically liberated at that time, in one point of your speech. Then how Nazis were prosecuted in the international court, given the fact that all these crimes happened inside the Germany. Right, number 1 question for you. And number 2 question for you, Shomila Ghosh. Given the fact 3 million Bengalis died and 4,000 women raped, how many Biharis died, as you mentioned?
Yes, the lady with the, yes, you. Yes.
Thank you. Okay, I'll be finishing quick. I have got just 2 questions. One is this to organizer, that this is organized by Sark Society, Oxford, India, Oxford, Pakistan. And I really see that the victim nation representation is not in the panel. Why is this? I really feel like one-sided. I came with very open-minded, but after starting these things, I terribly felt that this is one-sided. My second question to John Camille. You said that you are a traditional barrister, not human rights lawyers. And one point you said that I'm fighting a case. And I understand that your role is to support your client, assist them, and advise them. So in what capacity? Could you please explain? You are doing public event and lobbying and campaigning kind of things. And court case has not yet started in the court. The evidence is going to be on Thursday, the day of this month. And you commented about all those evidences, that those are false, not true from reports. How do you know that? Could you please explain that what capacity you are here lobbying and campaigning to the public event when you are supposed to be supporting your client? That is your objective, you very clearly say.
Well, thank you very much for coming to see it. It's not actually what I would call lobbying, it's participating in a...
Obviously lobbying.
Perhaps you could... well, I'll answer the question very simply. I'm a lawyer instructed by a client. I've been invited here to speak about the War Crimes Tribunal, where I have clients, regardless of their background, regardless of their political affiliation. You have to understand that is not my purpose, to push someone's political affiliation. I'm not supporting anybody's political affiliation. I'm supporting the fair rule of law. You can't have a jurisdiction that allows people... Look, let me emphasise this. I don't deny the horrors of 40 years ago. You have to accept that. I'm not here on a political platform, and it saddens me that a lot of you seem to think that I am. I'm not. I'm upholding the rule of law and fair justice that has to be seen to be done. And if you're going to lock people up for 14 months without charge, Does that really have a place in a modern free society? I'm not commenting on the evidence or the strength of the evidence. I haven't done that. The trial, as you rightly said, hasn't started yet. Let's wait and see what happens. I kept saying to you, can I just finish very briefly? I kept saying to you, this could be a wonderful opportunity, and let's hope that they take that. But so far, the measures, the removal of the rights of the accused, rights which you yourself would demand, is very worrying. And I'm not politically lobbying, I'm talking about a war crimes tribunal that appears to be heading for a dreadful confrontation with a lot of people in Bangladesh, and that would be an absolute tragedy. Sorry, the gentleman at the back. Sorry, I'm taking up your...
Yeah, what you said, like the Royal Society, he has been detained 14 months without any charge.
Yes.
But it happened before in Bangladesh. After 2007, present Prime Minister and former Prime Minister Khaleda Zia, they has been detained for 1 year without any, charge or acquisition, and that happened in Bangladesh. But
there have been...
It's not new in Bangladesh.
Yeah,
and it's not new in the subcontinent, means in South Asia.
I understand that.
In
Absolutely.
all the
Absolutely. But all I'm saying is, look, I'm representing clients in one trial. This is 2011. It's a wonderful opportunity to put an end to all of that, to go off on a new direction.
No, the incident I mentioned, it happened just from 2007 and 8.
Yes, I understand that.
Yeah. So this goes back to the first questioner, the sociology of and legal attitudes and practices in South Asia in general, which of course is quite true, and I don't think anyone is denying that. But I would, Sharmila, did you want to respond? Because there was a question to you as well.
Very briefly, because I don't want to take away time from the actual meat of the substance of today's discussion. 3 million people didn't die in that war. I suggest you read my book and other people and not persist with this absurdity. It doesn't do Bangladesh any favors if you carry on like that. A very large number of Biharis died, at least tens of thousands. I found thousands per incident. So there is some debate about how they add up. But if you just read, even if you read Mascarenhas, he had estimated in the middle of the year, and so war was not yet over, only part of it was over, in the early part of the bloodletting, his numbers, and I'm not saying he's correct, how would we know after all these years, but his estimate then had the two sides, the Biharis killed by Bengalis and Bengalis killed largely by the armed forces, in the same league. So that's Mascarenhas read. So it's not true what you're suggesting that only small numbers of Biharis were killed. A very, very large number, at least tens of thousands of Biharis were killed.
So you are saying
at par with the
large
others.
number of Biharis, they are residing in Bangladesh before.
Yes, of course. I think let's
I think the point I was trying to raise is the scale of the crime. I think this is
the scale of the crime. You see, if you carry on with the mythological number of 3 million, you get an absurd result.
It's even the US administration, they have.
No. Let's not digress. This is going to be a waste of time. Okay, please go and read some sensible things and forget about the 3 million and come to a
I was just wondering that if Bangladesh was international war tribunal mechanisms, if there was any way to involve members living in other countries in this process, because obviously, as Dr. Bose also pointed out, that the war did include atrocities by the Pakistan Army or accused atrocities, and if there is a mechanism in international war tribunals to include members who are now living in other countries, or would that require Pakistan to be involved in the tribunal itself, or will there be any extradition?
No,